2024 මේ 22 වන දින වරප්‍රසාද ප්‍රශ්නය යටතේ පාර්ලිමේන්තුවේ මතු කරන ලද කරුණු ආචාර්ය ධර්ම හා වරප්‍රසාද ග්‍රන්ථ කාර්ය සභාවට යොමු කරනු ලැබේ. පාර්ලිමේන්තු කටයුතු පිළිබඳ කාර්ය සභාවේ රැස්වීමක් 2024 ජූනි 18 නගහරුවාදා එනම් අද දින අපරභාග 1ට කාර්ය සභා කාමරාංක 2හිදී පැවැත්වීමට නියමිත බැවින් ඊට පැමිණ සහභාගී වන ලෙස සියලු ගරු සමාජික මන්ත්‍රීවරයන් සියලු දෙනා වෙත මෙයින් දැනුම් දීමට කැමැත් වෙමි. That's all. ජනාධිපතිතුමා.
The Honourable Speaker, you have read out the decision on the Gender Equality Bill.
Yes.
The determination of the Supreme Court on the Gender Equality Bill. That's right.
Yes.
So it has been read out by you. I just want to raise a point of order that it violates the powers of this House under Article 4 of the Constitution, and we should appoint a select committee. I would like to say first and foremost, the bill says, what is the national policy on gender equality and empowerment of women referred to in this bill? At the least, it's hard to find out. It's not specific as there is no reference in the bill. There has been a national policy on women's empowerment and gender equality since 2011. These are obligations of the government under the Sustainable Development Goals 5 and a number of women's conventions and agreements that we have signed. More than that, in the case of the Kamalavati and other versus the Provincial Public Service Commission, one SLR1, the national policy was deemed within the domain of the Cabinet of Ministers and Parliament. It's a political matter. The Supreme Court cannot in any way go and make any rulings on this. Then they are contravening and coming into our area. Secondly, there is a large number of cases which has been given on the question of equality and equality of women. There are Ratnayaka Taranga Lakmali versus Niroshan Abekon and the Inspector General of Police. It recognizes the dignity and well-being of people as a fundamental right. Then there are the 10 judge bench in Sarat Jaya Singh and others. We are of the view that mere reliance on the text used in a constitution is not sufficient to ascertain the values that are embodied in a constitution or its amendments. Similarly, you have the case where Shirani Bandaranaike's judgment in Karuna Tilaka and Jayalat De Silva and others, which says the basic principle governing the concept of equality is to remove unfairness and arbitrary. It is profoundly forbids action which denies equality and thereby discriminates. And finally, they have also ignored the determination, the special determination on the Penal Code amendment made by the Chief Justice. In this, we are talking of empowering women and ensuring equality for women. But according to the Goal 5 of Sustainable Development, even other minorities must get the government services without discrimination. That anyway follows from the average duties which are being given to us under fundamental rights. So all these powers have been disregarded. In a sense, the court has set aside everything and saying that this makes room. So in a way, what they have done is all these have disappeared, as if this court has eaten it up, all the other judgments. So in a way, they are practicing judicial cannibalism, and we are being asked then to accept it, which this House can't. How can you overrule a 10-judge bench, and how can you overrule the Chief Justice? So that is one area. Then they are saying that this will allow same-sex marriages and gender this thing. No, it has nothing to do with it. We can't allow that. They are going on this normal section which is put in every law by the legal draftsman, the AG, not by us. This law prevails over other laws, but this has also been interpreted it's finally for the court to decide. And I think in Chamara Sampath, not our honorable minister, but another person, and Neil Iddawela, they also referred to the points. This has been done by the doctrine of harmonious constructions. And the laws of marriage in this country can't be changed by one section. More than that, they say that the whole of the, basically the whole Pirivena Education Act can get knocked out by this. I don't know on what basis they have done. We have Article 9 which protects Buddhism, and I know this act because I'm one of those who drafted it and the minister who implemented it. It says, Pirivena Adhyapane Paramarthe, Pariyatti, Patipatti, Pativedi යන ත්‍රිවිධ ශාසනයේ ආරක්ෂාව හා අභිවෘද්ධිය කෙරෙහි භික්ෂුන් වහන්සේලා අතර උනන්දුවක් ඇති කිරීම සැදුත් මහ මුගලන් තෙරු පරම්පරාවෙන් පැවතෙන සංඝ පරපුර අවිජින්නව පවත්වාගෙන යාම සඳහා අවශ්‍ය විනය ත්‍රිපිටක ඥානීය ධර්මගරුක බව භික්ෂුන් වහන්සේලා අතර ඇති කිරීම මේ ඔක්කොම this been defended by this is been taken on by Article 9, and this, you think a small provision can change it. I don't think the Supreme Court or the bench that sat is even aware of what is Pariyatti, Patipatti, Pativeda. I think they should go to the temple and learn what this is, or to a Pirivena before coming and telling this house. We are aware of what is happening there. We have honorable member of the Sangha also. So these rights of what he is saying is that all the rights of the Buddhists can be taken away by one small section. And what is going to happen? All the protection for Buddhism has been removed. And the power of this Supreme Court finally has to go back to the 1972 Constitution, all of us. Any inherent powers, all must be justified by the Constituent Assembly and the 72 Constitution which this is built. Therefore, when it comes, the Supreme Court can't rule on a bill. They can only advise us on the value. It is basically a pre-legislative scrutiny. And what we did in the 78 Constitution, as one of those involved in this house, was that there had been, we transferred the powers of the Constitutional Court to the Supreme Court to ensure independence of the court is even further strengthened. That's all that we have done. But otherwise in 72, when the first instance came up and T.S. Fernando decided that the 2 weeks was not mandatory, the House overlooked it and ruled it out. I think the former President and Vasudeva Nanayakkar were members of the House, because these powers of the Supreme Court in all other matters come under justice, but this comes under, certainly this comes from the Parliament. In a sense, unlike the other courts, the Supreme Court is transgender. So that is what they fall into. They get from two genders, both from us and under Article 4C and from us under Article 4A. So I don't, this is really a perverse determination which this House should not follow. And I am going to recommend that a select committee be appointed to go into it. There are no need to summon the judges. I don't think we should go into that. There are enough that can be studied and they can recommend it, because majority of the members should be appointed by the Women's Caucus. After all, this concerns women. But what happens is it deprives the majority of this population, the women, of their rights, and it takes away the safeguard of another majority, the Buddhists in the Constitution. So we cannot accept it, and this House then has to assert its own rights. Secondly, Honorable Speaker, there is a matter on which I have to make an announcement. You know, there has been a lot of discussion and heartburn about the burials and what took place during COVID-19. You know, I was also there. Initially, all countries sort of stopped burials, and then it went to the WHO. But in Sri Lanka, we appointed a committee, and unfortunately, that committee recommended that we don't allow burial, while WHO took a different view. But then the Supreme Court also upheld the decision of the committee. So the government had to follow that. There was no choice at that stage. But now all this is over. And as we've gone through everything, this country requires the In this country, any person should have the right to determine whether he is buried or he or she is buried, cremated or given to the medical faculty. Therefore, the minister will bring a law which allows the right of burial, right of cremation or gifting your body to the medical institutions. During this time, there was a lot of pain witnessed mainly by the Muslims, but there are also Hindus, Buddhists I know, and Christians who also like to bury. So we'd like to apologize to them on what has happened, and I hope this House will will support the bill that will be presented in the House. Thirdly is that we are taking up the finance issues, and since I may not be here at that time, I just want to tell the House in regard to the rental income, we are going to have a wealth tax, and there will be a very high threshold. So 90% of the people's houses will not even be, one house will be exempt from it, so don't worry, your house is safe. Why is it we are going to rental income? No, this was based on rating. Then we came up with a problem. Rates belongs to the provincial council. So if we go on the rating business, there is a possibility that the court can say that this money belongs to the provincial council. So we want to get it here. So we have used a different formula called rental income. Your income tax belongs to the central government. It's the same. You would generally have used the ratings, but to get over the constitutional issue, that we have done this. But it's going to have a very high threshold, and I don't think the vast majority of the people in this country should even be worried about their house. So that's all. But we will have to get on to wealth tax. I know SJB is very, very worried that their billionaires who are with them will get tax. But nevertheless, this is the reason for it. Thank you.
Oh, Vipaksha Nayaka.